Hi everyone and welcome to another episode. Imagine you're selling goods to someone abroad. You ship them the goods but they don't pay you. What do? Do you sue them in their country or do you sue them in your country? This is where jurisdiction and choice of law clauses which you put into your contract at the time of signing the contract come into play. In this episode, I want to discuss what these clauses are and why they are so important. Let's get started. When we are entering into a contract, we are free to decide on every aspect of the contract and to enter into any terms that we want. Amongst these freedoms is the right to enter into jurisdiction and choice of law clauses. So what is a jurisdiction clause? A jurisdiction clause is a term in the agreement which the parties have agreed to, which specifies which country's courts have the right to hear a dispute if one were to arise between the parties. Let's say, for example, you're based in Sri Lanka and you enter into a contract with someone based in England. If there's a dispute between you and the other party, then the question comes up, which country's courts have the right to hear the case? But if your contract includes a jurisdiction clause that clearly says that the courts of Sri Lanka is the place of dispute resolution, then any dispute would have to be heard and resolved in the Sri Lankan court system. So what jurisdiction clauses do is that it pinpoints the exact court which has the right to resolve the dispute. Now, what these clauses refer to are geographical limitations of a court's authority, which may not necessarily be the same as a country's boundaries. So you have to be careful in making this choice and need to consider how the court system operates in different countries when entering into these jurisdiction clauses. For example, England and Wales share the same court system, but Scotland has its own court system. So a jurisdiction clause giving jurisdiction to the courts of the United Kingdom would not make sense and would not be enforceable because it would create confusion, since it would be impossible to know whether the parties meant the courts of England and Wales or the courts of Scotland. Also, when a country is divided into states like the United States or Australia, which are federal systems, it's important to specify which state you are giving jurisdiction to. So, for example, choosing the courts of New South Wales or Delaware would be valid and enforceable, but saying the courts of Australia or the courts of the United States would not be enforceable. It's also important to understand that there are three types of jurisdiction clauses. These are exclusive jurisdiction clauses, non-exclusive jurisdiction clauses, and asymmetric or unilateral jurisdiction clauses. An exclusive jurisdiction clause will clearly say that only the courts of one jurisdiction will have the right to hear a dispute if one were to arise between the parties. On the other hand, a non-exclusive jurisdiction clause will say that a particular courts will have the jurisdiction to hear a case, while also acknowledging that some other courts might have jurisdiction to hear the case as well. Finally, an asymmetric jurisdictional clause or a unilateral clause sets out that one party is restricted to suing in a particular jurisdiction, while the other party, who is usually the one who has more bargaining power, has a greater choice over where they want to initiate proceedings. Alright, next let's talk about choice of law clauses. Choice of law clauses are similar to jurisdiction clauses, but they will specify which country's law will govern the contract and any dispute that arises from that contract. This is important because different countries have different laws and have different ways of interpreting contracts. By specifying which country's laws will apply, both parties can have a clear understanding of their rights and obligations under the contract and know how the courts would interpret these obligations if a dispute were to arise. So a well-drafted choice of law clause can reduce the time it takes to resolve a dispute and save the parties some money. Now, with these jurisdiction and choice of law clauses, there is the possibility that one country's court might have to use another country's law in resolving the dispute. Going back to our example of the parties from Sri Lanka and England, the parties may have chosen the courts of England to hear the case, but may have chosen the Sri Lankan law to govern the dispute. In such a case, the English courts will have to apply the Sri Lankan law when resolving the dispute relating to the contract. In such instances, the parties will have to bring expert evidence to educate and prove to the English courts on what the Sri Lankan law is. This could be rather time-consuming and costly. So most often, the parties will choose a jurisdiction and the laws of that same jurisdiction to apply to the dispute to avoid any complications. However, the bottom line is without these clauses, resolving a dispute could become quite messy and expensive. So by including a jurisdiction and choice of law clause in your contracts, you can minimize the risk of costly legal battles and streamline the dispute resolution process if you end up needing it. So the next time you're signing a contract, make sure you pay attention to these important clauses. Because in contract law, a little bit of planning can go a long way. Anyway, that's it for this episode. Hope you enjoyed it. If you did, consider liking the video and subscribing to the channel. And also check out this video where I talk about 9 important features that you must consider when entering into a contract. I'll see you in another episode. Take care. Bye.